Generally, to recover in strict product liability, a plaintiff must prove that the product was defective. However, a product may be lost or destroyed, making it impossible for the plaintiff to prove that a product was defective by direct evidence. In such instances, a plaintiff may try to prove that the product was defective through indirect or circumstantial evidence. In the 1975 case, Friedman v. General Motors Corporation, the Ohio Supreme Court considered whether circumstantial evidence on the issue of defectiveness was sufficient to raise a jury question. On May 8, 1967, Morton Friedman was driving his 1966 Oldsmobile Toronado on a highway just outside of Cleveland, with his wife and two minor children as passengers. During the drive, Friedman noticed that he was running low on gas and pulled off the highway into a gas station. As Friedman pulled into the station, he stopped behind a Rambler that was being serviced and turned his car off. A few minutes later, the Rambler pulled ahead, and the gasoline attendant waved Friedman forward. As Friedman turned the keys, his car was in drive, and the car, quote, leaped forward, unquote, hitting the Rambler, a telephone pole, and a large sign. As a result, Friedman's car was severely damaged, and he, his wife, and two children were injured. Subsequently, Friedman sued General Motors Corporation, or GM, the manufacturer of the car, in the Court of Common Pleas in strict product liability. Specifically, Friedman argued that there were defective mechanisms in the car's automatic transmission that caused it to leap forward, because the engine shouldn't have started while the car was in drive. At trial, GM moved for a directed verdict, arguing that there was no direct evidence from which the jury could find that a defective condition existed at the time of the incident. The court granted the motion, and Friedman appealed to the Court of Appeals, which reversed and remanded. In so reversing, the court concluded that the jury could have found that a defect existed based on circumstantial evidence. GM appealed the decision to the Ohio Supreme Court.